How does binding arbitration work? Have you ever wondered how people resolve disputes without stepping into a courtroom? Binding arbitration is one interesting way to do just that. It is a process where two parties agree to settle their disagreements outside of the traditional court system. Instead of a judge, they turn to an impartial third-party arbitrator to make a decision. This decision is final and binding, meaning neither party can appeal it to a government court. The first step in binding arbitration is the agreement to arbitrate. This usually happens through a clause in a contract. Both parties must voluntarily agree to this process, which aligns with libertarian principles that emphasize voluntary contracts and agreements. This means that individuals and businesses can choose how they want to handle their disputes without being forced into a government system. Next comes the selection of the arbitrator. The parties involved get to choose who will act as their private judge. This selection process allows them to find someone who understands their specific needs and can make a fair decision based on the evidence presented. When it comes to the procedure, binding arbitration is generally quicker and less formal than going to court. The parties present their evidence and arguments to the arbitrator, who then makes a decision. This streamlined process can save time and resources, which is often appealing to those looking to resolve disputes efficiently. One of the main advantages of binding arbitration is its confidentiality. Unlike court trials, which are public, arbitration proceedings are private. This can be especially beneficial for businesses that want to avoid public scrutiny. Additionally, by resolving disputes privately, parties can steer clear of government regulations and court procedures. This aspect resonates with libertarian ideals of minimizing state involvement in personal and business matters. The voluntary nature of arbitration contracts aligns with libertarian principles of individual freedom. Parties are free to decide whether or not to agree to arbitration, reflecting their autonomy in making decisions about dispute resolution. However, there are some criticisms of binding arbitration. Some argue that it can limit access to justice, particularly for individuals who may not have equal bargaining power when entering contracts. Yet, from a libertarian viewpoint, the focus remains on the voluntary nature of these agreements and the efficiency they provide in resolving disputes without government oversight. In the context of libertarianism, binding arbitration stands as a form of private dispute resolution. It embodies the ideology's emphasis on individual freedom and minimal government intervention. By allowing parties to resolve disputes efficiently and privately, it reflects the preference for voluntary agreements and private solutions over state-controlled processes.